Hi, everyone. Welcome to the New Health, Privacy, and Security webinar. Thanks for joining.
Yeah, thank you for joining us and welcome to our webinar. We're thrilled to present to you today on an incredibly interesting and quickly evolving topic, health data privacy and security. One reason this is so important is that there's an increasing volume of health data that falls outside of HIPAA and can then fall into other privacy and data security laws. A lot of companies have been struggling with understanding where HIPAA and the Confidentiality of Medical Information Act, the CMIA, stop and the CCPA, the California Consumer Privacy Act, begins. This is one of the issues we're going to cover today. In addition, we're going to touch on a few other critical issues that are keeping the C-suite awake at night: data security and data sharing. We're going to frame these issues and hopefully give you some tools to help understand the risk associated with these issues. I am Shannon Yavorski. I'm an English-Irish solicitor and California attorney. I advise on a range of privacy laws, but like most privacy lawyers, have been very focused lately on the California Consumer Privacy Act and have been working very closely with my colleagues on advising companies on a wide range of privacy and security issues faced by companies that process health data. I'm joined by my wonderful partners and friends, Tora Johnson and Jamie Vibbert. Tora?
Hi, this is Tora. I lead Venables Healthcare Group. We represent health plans, health insurance companies, providers, and health IT companies with a range of healthcare regulatory needs. But in particular, I focus on federal and state laws governing the use and disclosure of medical data. On the front end, we do compliance work, setting up HIPAA compliance programs, for example. And then on the back end, we get the phone calls when things don't go exactly as planned, if there have been impermissible uses and disclosures, complaints, audits, or government investigations.
And hi, I'm Jamie Vibbert, and I'm a partner in the Privacy and Cybersecurity group here at Venables. I do a lot of data protection work and help companies create and strategize about how to use data, and I do this primarily for companies in the healthcare and life sciences space. Similar to my colleagues Shannon and Tora, I do a wide range of work in this space, so it's everything from compliance, helping companies get ready to comply with these types of laws, to diligence while acquiring companies, to crisis management in the wake of a breach.
Great. And our agenda today, we are going to provide you with an overview of the regulatory landscape, which is, as I said before, quickly evolving, talk about the CCPA and its relationship to the HIPAA and the CMIA, talk about reasonable security and IoT, talk about data sharing and interoperability, and then we're going to provide you with some key takeaways when you go back to your practice. So handing over to Tora.
Thanks, Shannon. So we wanted to take a minute and set the regulatory landscape for everyone. So as Shannon mentioned in the opening, it's a time of focus on health, privacy, and security, and we're seeing changes afoot on both the federal and state levels. On the federal level, we see possibly new HIPAA regulations and perhaps some finalization of proposed Part 2 regulations regarding substance use disorder. And really, to step back, in 2018, the government announced a regulatory sprint to coordinated care with the goals of decreasing burdens and incentivizing care coordination and value-based care with the patient at the very center. And we've already seen some movement on the federal level to this effect, being regulations under anti-kickback and Stark, and they signaled that there would be additional changes under HIPAA with a request for information that was issued in December of 2018. And then we had proposed Part 2 regulations that apply to substance use disorder treatment facilities and providers that came out in August of last year. So it may not be a regulatory sprint. It may be more of a marathon, but we see change on the horizon on the federal level, and perhaps more immediate, there are new CMS, ONC regulations expected, really addressing the flow of medical records and interoperability of systems that are expected in the next few weeks. Interestingly enough, all those federal changes I was just discussing are about data sharing, right, and this move to coordinated care. On the state level, a little bit in contrast, what we're seeing is a focus on data protection. And perhaps the way to think about it is the states are seeing this proliferation of medical data, some of which is outside the purviews of HIPAA, and a change on the federal front pushing the sharing of data, and so are reacting. And as Shannon mentioned, we're going to take the California Consumer Privacy Act and do a little bit of a deeper dive into what that would mean, or what it does mean, for healthcare companies. But we also see action under the New York SHIELD Act. And New York has been really quite active because they already have the NYS Department of Financial Services cybersecurity regulations. And Jamie's going to lead us through a look at what the SHIELD Act is bringing our way. And then I just want to plant a flag here for just traditional state statutes dealing with medical records. And they're interesting, and in particular, the Texas Medical Records Privacy Act. So traditionally, you think of these as the state statutes that govern providers and how they can use and disclose medical records. The Texas Medical Records Privacy Act is quite broad because it reaches entities who assemble, collect, analyze, evaluate, store, and transmit health information, both for-profit and non-profit, and they give as examples who you would expect to see, healthcare facilities, but they also include payers and researchers, and then information management entities and entities who maintain an internet site. And it's really a little mini HIPAA law at the state level, with notice and training obligations and prohibitions on sale and limitations on marketing. And I'm interested to see what you and my colleagues think on the phone about whether this is the end on both the federal and the state level, or just more to come.
I mean, I think when you look at the federal and state suite of regulations that Tora just walked through, I think you might at first think that these are kind of contrary interests, right? On the one side, you have a bunch of regulations seeking to share data and to increase access to data by patients, and in fact to use that data in different ways to encourage a more value-based care type program across the United States. And on the privacy side of the house, you have this recognition that personal data is much, much broader than what traditionally in the United States we thought of as personal data, which was kind of limited to credit card numbers and financial account numbers and Social Security numbers, and what everybody, I think, on the phone and on the webinar would agree is a pretty well-founded definition of personal information. I think they're not contrary. They are just two different types of regulations seeking to address technology, really. Technology and the opportunity that companies now have to use data in a way that improves patient outcomes, improves patient care, and reduces the cost of care. And so they want to both allow patients to have their data in their hands and to be more informed, but also make sure that that does not come at the price of patients losing their data to attackers or to other parties who shouldn't have access to it. And on the point of whether or not we're going to see more, I mean, I think, Shannon, you probably know the number better than I do, but there are at least 11 currently pending state privacy bills. And somebody told me this number the other day, and I've forgotten it already, but it's over 200 different bills that have been introduced at the federal level to try to standardize federal privacy law.
Okay. And so with that, handing it back over to Shannon and using the CCPA as just an illustration of the patchwork that is facing the healthcare industry with privacy.
Thanks, Tora. So for the CCPA, I'm going to provide a sort of high-level overview. I know a number of companies have been sort of living and breathing the CCPA for the past few months, if not a lot longer. I'm going to talk a little bit about who is covered, what is covered, and what you have to do. So in terms of who is covered, any company that does business in California and then meets one of the three standards that are set forth on the slide. So either has annual gross revenue over $25 million. We've had a number of conversations with clients who are close to that number as to whether they want to go ahead and comply with the law. The second prong is whether they collect or share personal information annually from 50,000 consumers, households, or devices. And someone helpfully pointed out that even a restaurant that takes 137 reservations a day would fall under this 50,000 consumers, households, or devices threshold. So a lot of companies had to think through that very carefully. And then the third prong is whether the company derives at least 50% of annual revenue from the sale of personal information. So again, it's a company that does business in California and meets one of these three standards. You don't have to meet them all, you just have to meet one of them in order for the CCPA to apply. It also applies to any entity that controls or is controlled by a business that shares common branding. And the reason this is important is that there is the ability for companies that have a sort of unified branding and are controlled by another company to share data freely amongst themselves. And I know that from a strategic perspective, a number of companies thought through that very carefully. In terms of what is covered, the CCPA introduced what I think of as the broadest definition of personal information in any privacy law. It's even broader than the definition of personal data under the General Data Protection Regulation, or the GDPR. It's information that identifies, relates to, describes, is reasonably capable of being associated with, or could reasonably be linked directly or indirectly with a particular consumer or household. So it's an incredibly broad definition. It can include things like identifiers, what you typically think of, so name and address, but also IP address or your unique persistent identifiers that are used to recognize a device linked to a consumer or family over time and across services. It also would include, internet and potentially other network activity information. So it's a really broad definition. However, there are things that are carved out of the definition of personal information. So aggregate information and information that's been de-identified does not constitute personal information for the purposes of the CCPA. In addition, information that's covered by a number of different federal and state laws is carved out of the CCPA. We're going to talk about this in a little bit more detail later, but certain information covered by HIPAA or the CMIA is carved out of the CCPA. And one of the tricky things about this definition is we've been advising clients on when personal information that may have started as protected health information could stop being PHI and then fall out of HIPAA and fall into the CCPA. So one example of that is where information starts as PHI, but inferences are drawn from it to create a new data set that doesn't necessarily contain PHI. And in that case, the CCPA may apply. So that's who's covered by the CCPA and a little bit about what is covered. Now, the biggest question from clients is, okay, so we know we're covered. We know what personal information's at issue. Now, what do we have to do? And I encourage clients to think about the core requirements of the CCPA as really being notice, access, deletion, and opt-out. So Access rights, this is similar to what people have had to do in with respect to other laws. For example, under the GDPR, there's a new consumer rights-based approach to privacy, and the CCPA sort of adopts a very, very similar approach. So businesses have to provide consumers with access to, in some circumstances, the categories of personal information that are collected about them, and in other circumstances may be required to provide the specific pieces of personal information that are collected about an individual. Deletion rights. So now consumers have the right to ask for their data to be deleted, subject to certain limited exemptions. And then opt-out. So consumers have the right to opt out of sales of their personal information. And it sounds simple enough. Oh, okay, well, we can just offer an opt-out. But there's a very broad and nuanced definition of sales in the CCPA, and it includes leasing, renting, sharing, in addition to traditional, what you would think of as sale of personal information. So it's very broad. And companies that sell personal information are required to have a do not sell my personal information or do not sell my info link on their websites. And you would have seen those popping up on websites starting at the beginning of January. Finally, the CCPA states that businesses can't discriminate against consumers who exercise their consumer rights. So next slide. And this slide sets out additionally some of the requirements under the CCPA. Businesses have to offer 2 methods for the consumer to exercise their rights. And you have to provide, if you're not going to respond to an access or deletion request, you have to tell consumers why you're not taking action. You have to provide information, the requested information, within 45 days. You can charge a reasonable fee or refuse to act on repetitious or manifestly unfounded or excessive requests. And there's a training requirement. So you have to train employees who handle consumer inquiries. And finally, you can't require consumers to create an account to exercise their rights. And this slide is really interesting because the implementation of the consumer rights is very similar to what companies went through with respect to the GDPR. So a lot of companies leveraged the work that they did for GDPR in implementing a consumer rights policy and expanded it or tailored it in order to comply with the CCPA. Another interesting point that I want to make here is that although the CCPA doesn't require you to carry out a data mapping exercise in the way that is required under the GDPR, in order to act on these consumer rights requests, companies have to know where the data lives in their organization. So they really have to do a data mapping exercise so that they can adequately respond to consumer rights requests. And that's something that we're increasingly thinking of as a real pillar of a privacy compliance program. So now I'm going to hand back over to Tora to talk about HIPAA.
Right, and why we're talking about HIPAA now is because the CCPA has some important exemptions, one of which is related to HIPAA. And so won't spend a lot of time on this slide. Presumably everybody is familiar, but entities subject to HIPAA are health plans, healthcare clearinghouses, and then providers that transmit health information in electronic form, basically as part of billing and payment operations. And HIPAA requires that the individual authorizes the use and disclosure of his or her information, generally speaking, unless the use or disclosure is for treatment, payment, or healthcare operations. And it has a security rule.
Yeah, and the security rule, it does list a ton of tiny little requirements of things about how you have to protect your protected health information. There are requirements about encryption and requirements about auditing and monitoring and all of the typical things that you're going to see under most security rules. The thing about the HIPAA security rule, and the thing that most people in security will tell you, is that it's flexible. And so whether or not you have to encrypt certain parts of your PHI depends. It depends on what other controls you have in place and and how sensitive the data is and what the threats to that data are. So it can be difficult to implement the security rule, but that flexibility is also a benefit to customers. I think there is also a security breach notification rule, and this will come up again later when we're talking about how HIPAA and the SHIELD Act kind of work together. But I think the one important thing to reiterate here was the point that we made before about states getting wise to the fact that PHI is actually not that broad, right? So the problem with the interaction of HIPAA and the interaction of state privacy laws is that HIPAA is really a entity-focused law. So whether or not HIPAA applies to you depends on the type of entity you are. Whether or not the CCPA applies depends on the type of information you have. And so these are not always coexistent pieces of information, and that's where some of the complexity comes in trying to figure out what law you should be complying with and when, and what the strictest requirements are, and how to handle this overlap of laws that may or may not apply to you and your health data. And the other point here about covered entities, so the HIPAA not only applies to these covered entities, but also to business associates who are servicing these covered entities up here. And a lot of times this is where digital health and other sorts of new technology and new types of data-related services will get brought in under HIPAA, but they might not be, and really whether or not they are depends on whether or not this is something that's being billed to insurance.
So Jamie mentioned stricter state laws, and HIPAA does not preempt stricter state laws, generally speaking. And so I like to think of a forgotten child is California's Confidentiality of Medical Information Act, the CMIA. And again, we mentioned HIPAA just now because the CCPA has a carve-out for HIPAA. It also has a carve-out of this Confidentiality of Medical Information Act. But unfortunately, HIPAA-covered entities don't actually have an out from having to comply with the CMIA to the extent that it is stricter than HIPAA. And so what does the CMIA govern? It governs medical information that includes an element of personal identifying information. And it is like HIPAA in that there's a privacy obligation, which generally speaking, you cannot use and disclose information unless an exception applies. And they're generally speaking like the TPO exemptions and the exceptions under HIPAA. There's also a confidentiality provision which says that health information must be created, maintained, preserved, stored in a confidential manner. Unlike HIPAA, the CMIA has a private right of action. But I'm sure people are going, private right of action under the CMIA, I've never heard of it. And there's good reason why you haven't, because there is case law dating back to 2014 in which the courts have held that it's not enough to have a breach of confidentiality just to have data that was accessed. There actually has to be, it can't just be viewed, it must actually have been acquired, and the burden of proof runs to the plaintiff. And I'm just teeing this up because, Jamie, I know you'll have strong feelings when we talk about the CCPA and data security.
Yeah, basically what courts have done with respect to the Confidentiality of Medical Information Act is cut the plaintiff's private right of action off, and they've done that by saying, and anybody who has had a breach will know that this is almost impossible. What they've done is say you have to show that somebody who was unauthorized actually saw it, and it is almost impossible to prove who stole information, particularly if it's an outside attacker. Now, the only time that this private right of action might be able to be proven by the plaintiffs is not when it's some random third-party hacker from the Ukraine, but when you have a situation where you have somebody in the hospital who looks at the celebrity's data and shouldn't have looked at it. That might be a place where the private right of action under the CMIA might get through. It's not going to get through when you have any external hacker, because the plaintiff is not going to be able to prove that who that external hacker is and that they actually looked at stuff. And that's why it hasn't been the bane of health data companies' existence for years.
Right. And the other thing that we should stop and discuss here under the CMIA is not only does it get to traditional healthcare providers and to managed care health plans, it also gets to a business organized for the purpose of maintaining medical information, not a primary purpose, but any purpose of which is to maintain medical information in order to make it available to an individual or a healthcare provider for purposes of allowing the individual to manage their health information and or for treatment purposes. And it also covers a business that offers software or a mobile app to provide such services. So you think of a mobile app that is allowing an individual to consolidate medical records. They'd be within the scope of the CMIA.
And because of the way that HIPAA is written and because of, frankly, excellent legislative advocacy work on behalf of those consolidators of medical records, that same entity would not be subject to HIPAA. So there are a whole host of entities that deal in health data that are subject to the CMIA who are not subject to HIPAA.
Right. And we thought it would make some sense here to present a chart that shows the individual rights under the various regimes that we're talking about. And Shannon, I'm not sure if you want to pipe in here.
Thanks so much, Tora. I love this slide. I think this is such a great slide to just help companies visualize the different consumer rights that are extended by the different laws across the U.S. and across Europe. And it's really important to see that there's a lot of overlap there. So when we're advising clients and we're thinking about their privacy compliance program and their individual rights policy, there are really strategic decisions that have to be made about whether you're going to apply individual rights, the set of rights that are extended under GDPR, only to people in Europe, and then are you going to only apply the rights under the CCPA to people in California, and so on and so on. So it's a really important decision for businesses to think about whether they're going to apply these rights across the board or they're going to limit them to a subset of consumers. And increasingly, this consumer rights-based approach to privacy, which originated in Europe, is really catching on in the U.S. and worldwide. The CCPA is a consumer rights-based approach to law, and many of the state laws that are currently being considered are consumer rights-based approaches. So they're more similar to the CCPA and GDPR in that they give consumers lots of these individual rights. And this goes back to what I think of, and I encourage clients to think about as another pillar of a scalable privacy program. So you do your data mapping because you need to know where your data lives, and then you figure out what your individual rights policy is going to be. Are you going to extend these rights across the board? And you have a policy that sets out the cascade of events that has to occur when someone makes an access request or someone makes a deletion request. And one of the critical things there is, okay, how are you going to verify the request? Is the way that you're verifying the request in Europe going to be the same way that you're verifying the request? We're verifying that the person is who they say they are under the CCPA because the requirements are slightly different. So we've had a lot of conversations about those things. Another thing that I would point out, again, I stick to my pillars of a scalable privacy and security program, is that the CCPA specifically requires companies to train any individual that's engaged in responding to individual rights requests. Again, there's a training requirement similarly under the GDPR. So again, training is becoming a pillar of a global, scalable privacy compliance program and making sure people are trained on how to respond to these individual rights requests. So that's what I really wanted to highlight on this slide. I'm sure Jamie and Zora have comments too. I'm going to hand back over.
Well, I think one of the things too, and everybody will be super surprised to hear that people are like, hey, do I have to comply with the CCPA or can I just wait for the federal privacy law to come out? And I just want to, I actually stole this from you, Shannon, but I'm going to say it as if it's my own. As people may or may not know, the GDPR is the consolidation of a lot of individual member states' laws that erased this member state by member state approach that was happening in the EU, and the individual state member state law privacy laws were in place for 10 years before the EU could get around to passing a law that standardized privacy across the EU. So, yes, you have to comply with the CCPA unless you're subject to one of the exemptions. Yes, you have to comply with the CCPA. We hope that there will be some standardization in the U.S. At the federal level, but just kind of given the experience that we've seen globally, that might take some time. Don't hold your breath is really what I mean to say.
So let's talk about, it's been a lot of wind-up, but let's talk about those carve-outs from the CCPA that are potentially applicable to folks on the phone. The most important are, for this group, the HIPAA and CMIA exemptions. What we're talking about first is an information carve-out. So all PHI, whether collected by a covered entity or those service providers to covered entities that Jamie mentioned, business associates, that are subject to HIPAA, are exempt from the CCPA. So PHI is out. Also is out is all medical information subject to the CMIA, out from the CCPA. Those two are information carve-outs. Now, I think we're going to take a little pause here and talk about another information carve-out for research because it may be particularly important to folks on the phone today.
Yeah, and what's in bill form and has not been passed, and so also don't hold your breath here. I've been told by people who are closer to the ground that unless McTaggart approves of something, it's not going to get passed, and I have no intel that he's approved of this particular bill. But there is a bill in the California Senate that would exempt additional information. And to go back to what Shannon said a couple of slides ago, there's that gap between what's considered de-identified data under HIPAA and what's considered de-identified data under the CCPA and therefore exempt. So you have this currently existing gap that if you de-identify something under HIPAA, it's no longer carved out by the information carve-out in the first, protected health information because it's no longer PHI because it's de-identified, but it's not de-identified under the CCPA, so it's subject to the CCPA. Well, this bill would fix that, and it would exempt all information that's considered de-identified under HIPAA, and so it doesn't have to also be de-identified under the CCPA. It also broadens, there's a currently existing exception for research data, but it's very narrow. And this would expand the exemption of research data so that most data that's overseen by an IRB will be exempted from the types of data that would be covered by CCPA. And that also includes data that's required to be maintained for safety purposes. And I think just from a policy perspective, this makes sense, right? one of the things about health data, it is super sensitive, and it is data that we should be caring about, but it's not really the type of data that the CCPA and other privacy laws like the CCPA were intending to cover. And so hopefully we will see this bill make it through the Senate.
Right. So information carve-out, PHI, medical data, maybe, well, currently some research data, maybe that will be broadened out. There's a second set of exemptions that are important for this group, and those are entity carve-outs. And so there's an entity carve-out for covered entities. Other patient information, i.e. not PHI, that is maintained by a covered entity is also exempted from the CCPA to the extent the covered entity maintains the patient information in the same manner as PHI. And that's interesting, right, because it does not extend to business associates, and it's using an undefined term, patient information, but then saying to the extent the covered entity maintains patient information in the same manner as PHI, there's a full entity exemption. And we'll dig in a little bit more on that in just a slide. Similarly, there's a CMIA exemption that is built the same way, which says a provider of health care covered by the CMIA is exempt from the CCPA to the extent the provider maintains patient information, again an undefined term, in the same manner as medical information.
And I will say that patient information, this lack of definition, gets fixed in that same bill that I was talking about with respect to the research data clarification is what I would call it. So really, it's quite complicated when you are sitting in the position where maybe you are a HIPAA-covered entity or a HIPAA business associate, or you're a provider of healthcare under the CMIA and you want to know how much of the data under the CCPA is exempted. Is it just the PHI and the medical information, or is it everything? And it's not clear, right? The CCPA is not well written. There are typos in the CCPA. There are inconsistencies. They passed it in, Shannon, like a week. It was very, very quickly put into place, and because of that, there's a lot of uncertainty. So we don't really know, but here are some of our thoughts. So there are both entity exceptions and information exceptions. And if the CCPA intended for the entity exceptions and the information exceptions to be coextensive, meaning that the entity exceptions only applied to the information exceptions, it would be completely redundant to have both. And so that is what indicates to us that the entity exceptions are broader, meaning it doesn't just apply to the protected health information or the medical information that's being held by that entity that's covered by the by either HIPAA or by the CMIA. The risk with respect to taking that kind of an approach, obviously, is that the California Attorney General might disagree with you. And this is a conversation that I've had a lot, this is a discussion that I've had quite frequently with my colleagues. I think that all companies should be compliant with all of the laws all of the time. However, that being said, there's not a huge risk to being wrong as long as it's reasonable. And the reason for that is that there is a 6-month cure period that the Attorney General has put into place. So if you take a reasonable read and say, how could they put in this redundant provision, I am a HIPAA-covered entity, and even though I have data that's not PHI, I don't know, marketing data, let's say, even though I have data that's not PHI, it's still exempted, because why would they have a redundant provision? And the AG comes out and says, no, you're wrong. It's all, it's only the PHI, and the redundancy was because we passed it in 2 days or whatever it was, and we wrote it wrong, which is what I'm going to make them say if they come to me with that. And we wrote it wrong, and you're wrong, and you need to fix it. Then you can say, okay, I'll fix it, and you have 6 months to do so, and you can cure it and move on, and nobody's harmed, and the AG's action can't come after you. The private right of action, I think this is a good point to really talk about the difference between the California Attorney General's enforcement and the private right of action under the CCPA, because the real risk is this private right of action under the CCPA. And the private right of action says, in summary, that if you are subject to a breach as that is defined by the California Breach Notification Statute, if you're subject to a breach and that was because you failed to have reasonable security or you had unreasonable security, then you can be liable not only to the Attorney General, but to private individuals. And I'm sure that my clients would kick me for saying this, but I typically find regulators much more reasonable than plaintiffs' attorneys. And so this is why I see this as a much larger risk under the CCPA than I see the Attorney General enforcement. There is an opportunity to cure from the private right of action, but we are all sitting around scratching our heads. If you've lost information, if you're subject to a breach, convincing a court that you've cured that breach when it's already gone, I think is going to be difficult, and I think that there will be a lot of litigation around that. Just to go a little bit more into what the enforcement actions look like, the Attorney General enforcement action. Shannon, I thought it was a 6-month cure period. Is it only 30 days?
It's just 30 days. Yeah, there's a 30-day cure period. I wish it was 6 months, but 30 days is still a long period of time.
It's still the risk is low. The risk is low because you have that cure period.
That's right. So there is this 30-day cure period. Another thing I want to highlight is that the draft CCPA regulations have not yet been finalized. We expect that they'll be finalized at some point this spring. And then the AG isn't going to enforce the law until July of this year. That does not mean, however, that the period between this January and July is off limits to the AG. I think it's important to bear that in mind. And just more on AG enforcement, the AG really supported this bill that was proposed last year that would have expanded the private right of action to any violation of the CCPA, but it did not proceed. So the private right of action is still limited to data breach, which Jamie talked about a little bit. The penalties that the AG can enforce, so it can seek an injunction plus civil penalties of up to $2,500 per violation or $7,500 per intentional violation. There's no cap on the civil penalties, and the AG is sort of incentivized to seek enforcement. The penalties and the settlement proceeds are placed in a state fund. Something else that I think is important to note is that there's no liability for CCPA violations of service providers or other entities that receive personal information under specific contract restrictions, as long as the company didn't have actual knowledge that the person intended to commit a violation. So I think when we're thinking about the risks overall with respect to this CCPA, there's the private right of action with respect to data breach, which Jamie's talked about. And then there's AG enforcement, and there's this 30-day cure period. So I really encourage people to contextualize that.
Yeah, that's be defensible, be accountable, and that will support the reasonableness of whatever decision you make under the CCPA if you're taking a position that might be controversial or might be found to be not right in the long run. To go back to that CCPA private right of action, so the private right of action, as I said, references out to this pre-existing data breach notification law, and the definition of personal information under the data breach notification law is different from the definition of personal information under the CCPA. And so for purposes of the private right of action, it's more in that traditional realm of personal information that we've talked about at the beginning, which is Social Security number, your driver's license number, your credit card number. But for individuals on this call, what's critical here is that there's medical information and health insurance information, which is included in the definition of personal information. So you have two basically different sets of requirements under the CCPA. You have a set of requirements that are related to privacy, and you have a set of requirements that are related to the reasonableness of your data security, and they apply to different data sets, which is super complex. The other thing is all of those exemptions that we were talking about before under the CCPA don't apply to the breach notification law. So, and that includes, and we didn't get into it in detail here, given that I think most people have been dealing with the CCPA for a while now, but the CCPA also exempts for a year employees' information and information of business contacts. Now, while I think that second bucket is not really helpful under the private right of action, that first bucket, if we were able to exempt employees, my guess is that there are a lot of companies that are dealing in medical information of their employees that don't otherwise have medical information, and the CCPA still applies, this private right of action still applies to those companies who only have medical information of their employees. You're going to get caught up by the CCPA, even though it exempts from the privacy side of the house, it exempts the employee information. So as I mentioned, you have this 30-day cure period. Again, I don't really know how that's going to work in data breach. I don't know if you're going to be able to cure a data breach. What I suspect will happen is that companies will argue that because the vulnerability that led to the breach has been fixed, that's the cure, and we'll just have to wait and see how courts handle that. So similar to the AG enforcement action, there are statutory damages. The damages are less, although I think most people who've experienced any sort of a data breach know that these numbers of $100 to $750 per consumer per incident is going to add up very, very, very quickly. And that can be a huge, huge penalty for a company who has pretty good security and just got hacked anyway. So that's what we perceive is going to happen. And frankly, for everybody on the phone, what I think is going to happen is people are going to start to give notice of security breaches under the CCPA, and as soon as enforcement is allowed, plaintiffs' attorneys are going to file class actions against those companies hand over fist. So we're going to see a lot of that happening. And I will say the reason that this statutory damages provision exists more than anything else, I think, is to get plaintiffs' attorneys over the hump that they've faced in data breach litigation thus far, which is an inability to prove standing because they cannot prove actual harm. If I lose my credit card, am I really harmed? Not that much. My credit card company removes all of the fraudulent charges. I'm not harmed by it. Maybe I have to spend some time getting a new card. It's not really that big of a deal. This statutory damages provision will get plaintiffs' attorneys over the hump that they've been facing and why data breach litigation, frankly, has decreased. The reason that reasonable security is important is because of that CCPA, but also a bunch of other reasons. But I will say, I think that one of the ways that you're going to be able to get around that private right of action is to come back in response to an action under the private right of action with a statement that you have reasonable security and actually a written statement that you have reasonable security. And I'll talk in just a second about what I think that looks like. There are a lot of other laws where you have to notify of breach of medical information or health information. There are several laws that have these reasonable security practices. You know, what reasonable is, not a lot of people know. I think I know, but you know, that will be tested soon under the CCPA's private right of action. There are unfair and deceptive acts laws in all of the 50 states that mirror the FTC's enforcement ability here, and so that's why you've seen the state AGs go after companies for failure to have reasonable security along with the FTC. There are specific requirements for certain types of information and for certain types of entities. So as an example, the New York SHIELD Act has biometric information, and with respect to that biometric information, you have to have very, very specific security requirements in place unless you can get out of compliance with that by fitting into an exemption, such as the Gramm-Leach-Bliley Act, which covers financial institutions, or if you're complying with the HIPAA security rule, which, as I said before, is basically a reasonable security requirement. And then Internet of Things devices, to go back to make your world all that more complicated. The Internet of Things reasonable security doesn't rely on information at all. So even devices that do not collect any data at all have to have reasonable security under, thank you, California. So if you have a connected medical device, as an example, doesn't matter if it doesn't contain information, it's going to be subject to reasonable security practices. If it's a medical device, it's also going to be subject to FDA cybersecurity requirements and guidance. And I will try to take a breath in a minute, but what you can do about it? Well, I think what you can do about it is to write it down. Do this risk assessment. Do a risk assessment in a way where you can protect it with privilege if you want to, but that you can disclose it if you don't want to. And what I mean by that is make sure that you're writing your risk assessment in a way where you are not giving yourself obligations that you cannot live up to. So do not create a risk assessment for your company that says that you're going to encrypt everything at rest and then find out 2 days later that it's going to cost you literally millions of dollars to encrypt your X database at rest, which is something that I've seen happen. So do a risk assessment, make sure it's thorough, make sure it covers your entire organization. It probably helps to do your data map first, per Shannon, and be ready to hand it over if you need to hand it over to get that plaintiff's attorney to go away. And so you don't want to write things down in there that you're not going to follow.
And so now we have just run through some of the state laws and the need for reasonable security, and I just wanted to come back here for a moment to what the feds are doing with the sharing of data. And just a few words here before we give you some takeaways, which is, again, we should be seeing regulations in the next few weeks out of CMS and ONC, which will require providers and plans to give patients access to their data, and the ease of transporting that data through APIs to apps within their control, patients at the center. And that should theoretically make it easier for them to organize it, for them to decide how to share it and with whom to share it, and whether it gets donated to research. But when you look at least those proposed regulations, there's a little bit of tension of what they are requiring of Medicare plans and managed Medicaid plans and exchange plans. They're requiring some mandatory disclosures. And so that RFI under HIPAA would be to ease and align what are currently permissive disclosures under HIPAA. We may see a movement to more required disclosures to get that patient in control of their medical information, and might see some easing perhaps of minimum necessary and accelerated timeframes for getting information moving and in the hands of individuals. And quite frankly, we've seen some OCR enforcement in the last year on following through on an individual's right to access, which, thanks to the slide a few slides back, is pretty uniform to all of the regimes we've been talking about, getting patients the rights to their information. And as part of this, I don't want to leave out, we are in the middle of a drug epidemic and the Part 2 regulations and maybe some easing of substance use disorder records, but that is a largely statutory regime, so that may be harder. And there are some very strong reasons for the fact that substance use disorder records are more tightly locked down and are not freely shareable. So Shannon, do you wanna conclude our program today?
Thanks so much, Tora. So as Tora was just saying, more data sharing required and encouraged, more individual rights, and like I said earlier, doing a data map and understanding your data flows is critical to be able to comply with requirements, which means that, data mapping and governance is critical. You need to identify personal information that's subject to HIPAA, what's subject to the CMIA, what's subject to the GDPR, what's carved out of the CCPA. It's really, really important for your responding to individual rights requests and having a good scalable privacy and security program. There's continued importance of security risk assessments. Jamie highlighted the dangers associated with having a poorly managed data security program and the risks under the CCPA with respect to private rights of action. Privacy and security are increasingly giving companies a competitive edge. It helps brand integrity and consumer confidence in companies if they are good corporate citizens with respect to privacy and security. Know that there is continued government enforcement. Data litigation is on the rise, and like Jamie said, we might see a spate of lawsuits in relation to data breach in California. And so there's no time to be complacent. Change is constant. The CCPA is a wonderful opportunity for companies to think about a scalable privacy and data security program and reduce overall risk. For companies that have health data, it's critical to keep on top of these developments. As Tora said, the legislative landscape, the regulatory landscape is shifting all the time. So thank you so much for joining. Thank you, Tora. Thank you, Jamie.
Thanks, Shannon.
Thanks, everyone.
Thanks, everyone on the phone.